Antitrust single entity immunity. In a decision that could prove significant to all businesses that engage in joint ventures and other cooperative enterprises, the Supreme Court ruled today in American Needle, National Football League, that NFL doesn't constitute a single enterprise for antitrust purposes, holding instead that the league's 32 constituent teams are separate enterprises when it comes to selling branded items like caps. In 2000, the NFL entered into an exclusive licensing agreement with Reebok International Ltd. to produce cap and other headwear bearing the trademark or logos of NFL team. As a result, other vendors, including American Needle, lost their license. American Needle sued, claiming that because each NFL team owns its own logos and marks, the exclusive agreement was a conspiracy to restrain competition in violation of Section 1 of the Sherman Act, which prohibits contract, combination, or conspiracies in restraint of trade. In response, the NFL, relying on Copperwell Corp Independence Tube Corp, argued that the league and its team, like a parent and its subsidiary corporation, constitute a single entity for antitrust purposes. American Needle, the district court agreed, granting summary judgment to the NFL and the Seventh Circuit affirmed. In opinion by Justice Stevens, the Supreme Court reversed, holding that the NFL's joint licensing of team trademarks may be challenged under the Sherman Act. The court explained that in analyzing concerted action under the Act, the relevant inquiry is whether there is a contract, combination, or conspiracy among separate economic actors pursuing separate economic interests, such that the agreement deprives the marketplace of independent centers of decision making and therefore of diversity of entrepreneurial interests. Slip up. 10. Applying that test to the NFL, the court found that each of the league's constituent teams is a substantial, independently owned and independently managed business, and that each competes with the others not only on the playing field but in the market for intellectual property. Characterizing the various teams as potentially competing suppliers of valuable trademarks, the court found that when licensing the respective trademarks, the teams are not pursuing the common interests of the whole league, but are interests acting as separate economic actors pursuing separate economic interests. Accordingly, the court concluded the fact that the league's team depend on cooperating among themselves didn't make them a single enterprise immune from antitrust liability. Under Title VII of the Civil Rights Act of 1964, a plaintiff suing for employment discrimination must have first filed a charge of discrimination with the Equal Employment Opportunity Commission (EEOC) within 300 days after the unlawful employment practice occurred. The Supreme Court held a plaintiff who doesn't file a timely EEOC charge challenging the adoption of a practice may nevertheless assert a disparate impact claim in a timely charge challenging the employer's later application of that practice, as long as the plaintiff alleges each element of a disparate impact claim. Petitioners plaintiff below are a class of African American who applied for position as firefighters for the city of Chicago. To select firefighters, the city administered an examination in 1995 that sorted applicants to three categories: not qualified, qualified, and well qualified. Well qualified and qualified applicants were placed on an eligibility list to be drawn from in the future. Should need arise, although first priority was given to well-qualified applicants. From 1996 until 2002, the city selected 9 classes of applicants from the eligibility list. Only in the last round did the city extend offers to qualified applicants. Petitioners who were classified as qualified contended that the exam has a disparate impact and thus violated Title VII. After filing a charge with the EEOC in 1997 and receiving right to sue letters, petitioner filed suit in district court, obtained class certification, and ultimately prevailed on the merits. The Seventh Circuit reserved, holding that the suit was ultimately because petitioner filed the AEOZ chart more than 30 days after their test scores were sorted into categories. Thank you.